Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 160544, Elmer R. Parsons et al. Versus Jonathan NACE et al. Council will remind you that this oral argument is being recorded, both video and audio. So if you would please state your names and who you represent at the beginning of your arguments, that would be appreciated. Each side will have 20 minutes in which to argue your respective positions. And counsel for appellant, if you'll watch the clock and reserve as much time as you deem appropriate for rebuttal. Also, please keep in mind we've read the briefs. We've also conferenced the case, so we're familiar with the basics, background of the case. With that, counsel for appellant, you may proceed.
Good morning. My name is Teresa Foster, and I represent the appellants, Jonathan NACE, Christopher NACE, and Dean Brayton. Since you've read the briefs, I want to get to the real underlying issue, and that is whether or not a co-beneficiary under a deed of trust owes the other beneficiaries a breach of duty, and whether or not they would have breached that duty by purchasing tax liens on the subject property. In this case, Buckeye owned some property that had delinquent tax liens. The property was subject to 3 separate deeds of trust. The first deed of trust had 5 beneficiaries, and those 5 beneficiaries are the parties to this appeal. Appellants collectively owned approximately 25% interest in that deed of trust, and the appellees collectively owned approximately 75%. The total amount of that deed of trust was $2.6 million. The appellees purchased the tax liens, and the property was subject to 2 separate tax lien foreclosures, the 2013 case and the 2014 case. On one, the appellees filed their own tax lien foreclosure, and on the other, they were substituted in as plaintiff. What occurred is there was 3 separate parcels that were adjacent that were owned by Buckeye, and so there were 3 separate tax lien certificates. When the NACEs came into this proceeding, there was a bankruptcy. The bankruptcy was dismissed, and my clients, the appellants, filed an answer and a counterclaim. And that's where we get to the issue. In the counterclaim, the appellants had argued that because Parsons and the trust were both beneficiaries under that deed of trust, that they owed fiduciary duties. And by going around the other beneficiaries and acquiring that tax lien, it should have been for the benefit of all.
Question. You just used the language going around the other beneficiaries. Was there something fraudulent? Was there any concealment? That's what I'm missing in this record.
Your Honor, no, there was nothing fraudulent, and there was no concealment. Unfortunately, there was language in this deed of trust, a couple of provisions, and one that only allowed Parsons to advance money to protect the property, which would include the tax liens.
But that ignores the preservation of the property in the deed of trust that says any beneficiary under this deed of trust may do whatever it takes to preserve the asset.
But that's not what Parsons did. He did not take an action under the deed of trust to preserve the assets, which he could have done. Instead, he went around and purchased the tax liens individually.
Are you saying he was required to do that?
I'm not saying that he was required to. The way the deed of trust is that the beneficiary, and it's a deed of trust that really is talking about one borrower and one lender, but we've got these 5 co-beneficiaries. It authorized a beneficiary to advance funds. The problem is that Parsons and the trust own 75%. If the other beneficiaries, and they offered to advance their pro rata share, they offered to advance their 25% before the foreclosures began, after the foreclosures were instituted, and even tendered their 25%, and it wasn't exactly 25%, but it was very close, after the bankruptcy, so that they could share pro rata in that, and that was rejected.
When you talk about the pro rata share, Parsons ended up paying the full bill. Would you agree?
On the tax lien?
Correct.
My understanding is Parsons and the trust paid that, but I don't know how that was taken care of, yes.
So had your clients done the exact same thing, how does that put them in a different position than they are now?
Well, if my clients could have afforded to do the exact same thing, and we're talking about close to $400,000 in back taxes, they would have advanced it under the deed of trust, and it would have been for the benefit of all. But unfortunately, the way the deed of trust was written, if Parsons didn't consent to it, it would have been a gift. They never would have gotten reimbursed for that amount.
I mean, isn't that okay? Back up. You say your clients would have done it for the benefit of all. Why wouldn't your clients, if they had the $400,000, why wouldn't they have done the exact same thing that Mr. Parsons did here? And why wouldn't that be perfectly acceptable? I mean, in other words, bought the tax liens and foreclosed.
Because they were actually co-beneficiaries with Parsons under a deed of trust. The way that I look at it, the way my clients looked at it, the parties were basically like a partnership, and there was fiduciary duties to the different partners under that agreement. I know that the appellees have argued that there was no contractual relationship between Parsons and the trust and the other beneficiaries, but they were all parties to that deed of trust. In Arizona, only the borrower signs that deed of trust, but all parties are a part of that deed of trust, and all parties negotiated that deed of trust. So there was contractual obligations, and I believe fiduciary duties between the parties under that deed of trust.
Okay, I'd like to go back. I'd like to have a better understanding of what exactly the relief you're seeking. Are you saying that, okay, let's assume that for argument's sake that there were fiduciary duties owed, but that doesn't mean, are you saying that would have prevented the purchase of the tax certificates and the foreclosure, or are you just saying, well, we need to share in that benefit? Is it the former, the latter, or both?
Buckeye, the owner, raised the argument of the first argument, which I do not represent Buckeye. Ours is the latter, that the purchase by one or two beneficiaries should have been for the benefit of all five of the beneficiaries.
And had Parsons not stepped in and bought the tax certificates, and I think it's Colonia, is that how you say it? Colonia?
That's the way it's spelled.
Okay.
I'm not sure how it's pronounced, Your Honor.
And Colonia foreclosed on the tax certificates. They would have lost all of their interest as well.
Your Honor, they would have. Don NACE, who was a member with Parsons in the LLC, did offer to borrow money to pay off those tax liens, but requested there be a subordination because the tax liens were first, the new lender would be first because they had paid for the tax liens, and Parsons had refused that.
Okay, to follow up on that, why not redeem then? If Don NACE, well, you don't need any subordination to redeem. Why not just redeem before judgment becomes final? Either the property owner, either Don NACE, who is not a party to this, or the minority, call them the minority beneficiaries. Why not? Why couldn't they? Why didn't they? That's probably a dumb question. Why couldn't they redeem?
Your Honor, I don't represent Don NACE or the LLC, but my assumption is they didn't have the $400,000 to redeem the total. The beneficiaries had enough to redeem their pro rata share, but they did not have enough for the total. The beneficiaries that I represent only owned approximately 25%.
But legally, they could have. Clearly, they could have redeemed. Legally, from a legal
legally, any owner or any beneficiary could have redeemed. Yes, Your Honor.
And if we were accepting your position that everybody gets to share in this, okay, explain to me what the title looks like. Does the title mirror? I mean, is there a 68% and a 7%, and your three clients would own 25? What would the title look like, and how would Mr. Parsons be reimbursed for all the money, and what about his effort, and what about his effort in selling the property or trying to sell the property? I mean, how would this work in practice, what you're trying to advocate for?
Your Honor, in practice, the title would be the same percentages that are outlined in the deed of trust. It gives each beneficiary a particular percentage in the deed of trust. And if there were any cost of sales, obviously when the property got sold, those would come off of the top, and Parsons would be reimbursed for those with the proceeds, the net proceeds for the sale being allocated in the same percentage as the parties contributed to the tax lien foreclosure sale, which would be the same percentage under the deed of trust.
Well, when would your clients pay the tax? And they would owe him money for the taxes, wouldn't they?
They actually did tender their pro rata share, Your Honor, and it was rejected.
Well, that was back then. Did that include attorney's fees? I mean, and everything? I mean, You see the difficulty here with this concept. It's easier said than done. And what I'm struggling with is your clients had the opportunity, absolute legal right to redeem the taxes, and they did not. And I'm so maybe we can transition into some of the case law. What is the best case that you have supporting you for the concept of we share and share alike?
The best case, Sharon, and there's only two cases really in Arizona that I believe are even relevant, and that's the Stoltz versus Maloney and the Kamen versus Day. Stoltz is a different situation because the tenants in common actually were assessed their taxes separately. I mean, that would be a situation here if Buckeye had 5 different assessments and they were based on the percentage ownership. And if that was the case, my clients could have redeemed their share and we wouldn't be here today. But the Stoltz case was interesting because it actually cited a treatise, which is Bogart on trust and trustees. And one of the sections in Bogart's, and we quote this in our reply, is that co-beneficiaries are owners of equitable interest in the same rests and are generally tenants in common. They are in a fiduciary relation to each other. And this goes on to state that if the taxes on the trust property are delinquent and one beneficiary takes a tax deed for the premises, the other beneficiaries may obtain a proportionate interest in the tax title on bearing their part of the expense involved. And that's from the Bogart treatise, which was cited in Stoltz. But it's Kamen Consultants that I think really goes through what the public policy is on this. Kamen Consultants involved an owner of property as opposed to a beneficiary, but the court looked to laws, and this is Division 2, looked to cases in other jurisdictions that relied on the issues with mortgagees or beneficiaries. And in Kamen, when Justice bought the property, it was subject to a prior lien in favor of Day, and it was also had delinquent taxes that were owed on it. Justice formed a corporation and tried to basically buy the tax liens and wipe out the junior lien. And the trial court held that the sale of the tax liens by an agent of the owner is contrary to public policy and unfair to the lien holders. When the Court of Appeals looked...
When we look at that case, we talk about disregarding the corporate structure. We talk about all kinds of different things that aren't applicable here. What it seemed the court was saying in that case was the property owner was engaged in some sort of shenanigans. So where are the shenanigans in this transaction? Where is the fraud? Where is the concealment? Where is the bad acting?
And, Your Honor, you're correct. The court went through that because there was a corporation involved, and it basically went through the shenanigans to get down to justice. And it assumed that justice was the one that made this order, so made this purchase. So that's why they went through the shenanigans. But when the court looked at this, they said that the rule, and this is a Court of Appeals decision, that the rule includes those whose duty it is to pay taxes or who have such an interest in the property that they might redeem the same from tax sale and save themselves from loss and injury. Lenders, just like owners, have the right to redeem. And the court in Kamen went and looked at Vulcan Materials, which is an Illinois case, and it basically held the same thing with regards to owners as it does with regards to mortgagees. And here in Arizona, we have beneficiaries.
Agreed. But when we talk about, let's talk about a bank in first position.
Sure.
Then we have junior liens. It is not uncommon for someone further down the line to wipe out the lesser liens. Would you agree?
The prior lien wiped out lesser ones. Yes, correct.
Okay.
Yes.
How is that different than what we have here?
I mean, how's that different what we have here?
I mean, we have a lender who is 5 separate individuals. Mm-hmm. They've all invested in this property trying to make a profit. Agreed. That's
Agreed.
Why we invest. Why do you have any duty to the others in an investment sort of arrangement, number one? And number two, don't each of the individuals have a duty to preserve their investment?
And that's what my clients tried to do to preserve their investment, was to offer before the foreclosures began to pay their pro rata share of the taxes. Unfortunately, under the deed of trust, they had no authority to require everyone to contribute. They needed Parsons' consent. They were willing to pay their pro rata share. Unfortunately, they could not afford to pay everyone else's share.
Did they ever give Parsons a demand that said, we hereby demand that you pay the taxes that you pay the delinquent taxes? Here's our proportionate share to go with that. I mean, a formal demand. asking him to do that?
Your Honor, that's not part of the record, but I don't believe so, because I think if it was there, I would have heard about it. All I know is that Don Nace had submitted a declaration in the trial court saying that they met every time the tax notices came out and they discussed this issue, and Parsons had refused. I don't believe it was refuted, but I don't remember. But no, to my knowledge, there was no written demand. Although after the bankruptcy was dismissed, the beneficiaries did contribute their pro rata share, which was rejected. I'd like to reserve some time for rebuttal, if that's okay, unless you have another question.
Thank you.
Thank you.
Thank you.
Good morning. Thank you, Your Honors. May it please the Court. And with me is my partner, Kristen Roebuck, who is assisting me and helping me with this case. Your Honors, there's an old saying, a person never missed an opportunity to miss an opportunity. And that is exactly what happened in this case. The appellants, from the very beginning, could have redeemed. Under ARS 42-18151. And let's talk about what practically would have happened if they had chosen to do that. They would have gone to the treasurer's office, and they had years to do this because there was a bankruptcy that they filed, that Don Nace filed for all of them. And that bankruptcy was eventually dismissed. But it was caught up in bankruptcy court for a solid year and a half. And before it was dismissed and sent back to the trial court. At any time, they could have gone to the treasurer's office to redeem. This very issue came up in bankruptcy court. They never did. So they never redeemed. And it wasn't a secret. It wasn't a secret that Elmer Parsons, on the brink, well, not even on the brink, Colonia had literally foreclosed on one parcel of this real estate. So the property had been foreclosed on when Elmer Parsons bought the tax liens. Nobody else bought them. Years after the fact, Don Nace, in defending, in trying to get a motion for summary judgment, or in the procedure, in one of the pleadings, because there were so many pleadings with each side was filing for their own motions for summary judgment. But on behalf of the appellants, Don Nace filed a declaration. The declaration had no dates, had no times, had no places of where these meetings have occurred, had no...
So are you denying that from your perspective, that those meetings did occur?
Absolutely, we denied it in the trial court. And it was irrelevant anyway, because Don Nace was the manager of Buckeye. Buckeye owned the property. In the operating agreement, and the court has read the briefs and is familiar with the record, in the operating agreement, only Don Nace was able to make these decisions. Only Don Nace didn't even, it wouldn't have been proper for Don Nace to be meeting with Elmer Parsons and saying, why don't you fess up and pay the taxes? You have a duty to do this. The point is, under the operating agreement, as Judge Gama recognized, there was no duty to do it.
Well, as between those two individuals, I mean, what about between the 5 individuals? They could certainly, I mean, couldn't they approach Mr. Parsons and say...
They could, but
Yeah.
there was no documentary evidence that they
Yeah,
ever
but
did.
They could have. Okay.
They could have.
And then to that point, why? Okay, as I'm reading this document, and I'm wondering why it says that he's going to essentially act as he's the majority interest holder here, so I guess it makes sense. But he takes upon himself certain duties, if you will. I mean, he takes.
Are you talking about Mr. Parsons?
Yes. He takes upon himself the right, if you will, to veto a foreclosure.
Let's talk about that.
Okay.
I'm
Doesn't
sorry.
it say that in black and white?
Yes, and
Okay.
and here's the thing, Your Honor. The appellees with counsel, as we put in the record below, and there's been no contradiction of this. I mean, the appellants, the NACEs, they signed this document. People sign documents every day limiting their
document
right.
did they sign?
The deed of trust.
Where is it signed? It's signed by all the beneficiaries?
Well, I mean, I believe they
I
signed.
don't think, okay.
They signed the promissory note, and the promissory note is also in evidence in the record. They signed.
Do you know where it is?
Yes,
Because
we have it. I don't want to use up my time.
Okay.
My partner,
Okay.
but it's in the record.
I'm just wondering,
and
regardless.
they were aware of this deed of trust. I mean, they're not saying.
But how does that, you're not getting to the point. The point is, he took upon himself, I guess, I don't know who insisted on those provisions being in the deed of trust, apparently probably at his request, that he would have the right to veto certain things. Why doesn't that put him on a different plane than perhaps just if there were just 5 names on a piece of paper in a deed of trust without those provisions?
Because they willingly entered into this. They could have said, we're not putting our names on this deed of trust. We're not doing this if that line is in there. But not only that, Your Honor, there's another line in there that says they have to ask his permission, but there's nothing in the record that says that they ever asked his permission. They didn't ask his permission. They're not even saying that they asked his permission.
So in your view, this is a simple contract matter that they could have alleged, I mean, they could have sought to sort of set up a breach, if you will.
Yes.
They did not.
That's exactly right. They did not. And even if we get through all of that, even if all of those steps are analyzed, then we have the statute. 42-18151. Who may redeem real property tax liens? Persons owning partial interest. This gives them the right. This takes precedence over everything. And when Elmer Parsons filed his complaint, he had to send notice to everybody, including the NACEs, including everybody with any interest in the case, 3rd lien, 4th lien, that anybody was permitted to go to the treasurer's office, and we had to send a letter to everybody in accordance with the statute. Nobody is alleging.
So, appellants tell us that the Kamen Consultants Corp. Opinion leads to the conclusion that a fiduciary relationship exists among co-beneficiaries under a deed of trust like this one, such that one may not take advantage of the non-payment of taxes to the detriment of another's equitable interest in the property. Why does that statute not have to be read in conjunction with that case law?
Here's
and where
why.
does that take us?
Here's why, Your Honor. I think it goes back to what, respectfully, Judge Campbell was raising. Kamen Consultants and Vulcan, to which Kamen Consultants cites, that case was built on an extreme set of facts. The owner, Mr. Justice, owed the taxes. Very important in this court's analysis is the fact that, and I'll get to more distinctions, but Mr. Justice owed that. Not only did he owe the taxes, but he owed Mr. Day a $200,000 mechanics lien. So what did he do? He secretly and fraudulently, unlike what happened here, started a cover corporation, which was a sham, which was Kamen Consultants, and they never had any meetings. They talked about the fact that that was just a fraudulent corporation, and he had Kamen Consultants go down and buy the taxes as if they were a disinterested third party. And because they were able to do that, they wiped out Mr. Day.
Why couldn't Mr. Dave redeem the taxes?
Well, he
could have redeemed out of foreclosure, just like you're saying.
He could
here.
have, but there, what happened is the court looked at this and said, "This is so egregious. This is the owner. This is an owner who was liable for the taxes in the first place." And let me distinguish our case. Because it's so important. When this deed of trust was entered into, back in April 28th, 2009, there were taxes owed on the property going back to 2007. So these taxes were owed, which is very important, before Mr. Parsons or the NACEs or anybody came on the scene to buy this property. that was no secret. Those taxes were incurred by the previous owners. Mr. Parsons never incurred those taxes. Mr. Parsons never had a duty to pay those taxes. Mr. Parsons never owned the property. Buckeye owned the property.
Oh, tax liability accrued during the time that the
Yes,
LLC
it kept accruing. But Mr.
weren't-
Parsons bought the taxes that had been after 3 years. 3 years have to go by before you can buy taxes. And he bought those taxes that had already been accruing before he even owned the deed of trust. And why is that important? Well, first of all, it shows, again, like we don't even have to show it because there was never a duty of Mr. Parsons to pay those taxes. In fact, he was prevented from doing so in the operating agreement. But
But he had the absolute right to do it under the deed of trust.
he had the right to do it, but the deed of trust, everybody had the right to do it,
So when
including...
he did, I noticed that this one that troubles me a little bit. It seems to me that there's been some focus on what hat he was wearing, or what capacity, in which capacity he purchased. Does that even matter?
I don't think it matters. He was an individual that was doing exactly what Judge Campbell described. He was stepping in. He was the only one that stepped in, and the bankruptcy court.
So if the shoe were on the other foot, if any, like the question I asked a bit ago to opposing counsel, if one of the other one of her clients, if they had done the same exact thing, even if they're a 3% owner, it would be fine under the law.
Yes, and and guess what, Your Honor? The Ellingsons approached Mr. Parsons and said, "Can we go in with you to buy the tax liens?" And the NACEs could have done the same thing. I mean, nobody prevented them from doing exactly what the Ellingsons did, and they did it. And if the shoe was on the other foot, Mr. Parsons would have gone down and redeemed, probably, or not. But whoever redeems, it's such an important statutory right because, yes, Mr. Parsons then would have owned, I think I pointed this out already, stop me if I did. Mr. Parsons would have then, what would have happened if they would have redeemed? Well, if they would have redeemed, if the appellants would have redeemed, then Mr. Parsons would have owned that property subject to the deed of trust of the appellants. And then the appellants would have been able to foreclose on Mr. Parsons. And Mr. Parsons would have had to either lose the property or pay them their $70,000 or whatever to be flush. And that's why the statute exists.
Okay, can we go back to the beginning of this transaction where they're doing the deed of trust and
Yes.
Buckeye owns the property and there's outstanding taxes?
Yes.
Are you telling me that 5 individuals put up the money to purchase this with no plan to pay the back taxes?
Well, I mean, it's not in the record. It really.
Not.
It's
I'm
not
just
in the
curious.
Record. It's not in the. Your Honors, it's not in the record. The point is, everybody that starts a company, Buckeye,
Is
I think
optimistic.
Yes. And if you remember back to when this happened, I don't have to remind everybody. We've all lived through it. It was between 2007 and 2009. The economy was literally collapsing. I remember we were literally standing in bankruptcy court one day, and everybody was wondering if the stock market would go below 7,000 that day. I mean, this was a very bad time in our economy. So yes, they were optimistic, but that's why everybody was in bankruptcy court, and that's where this purchase came from. Mr. Parsons was the one that put up the hard cash, as was recognized by the bankruptcy court, and is recognized by this court, and was recognized by Judge Gama. There was nothing deceitful. Appellants have, thank goodness, admitted that. There was nothing deceitful, nothing fraudulent, nothing tricky. Mr. Parsons didn't go out, which he could have done, and started his own secret LLC and called it, Sky Investments LLC, just like they did in Kamen, and he could have gone down under somebody else's name and done this. But he did it as Elmer Parsons, and he sent proper statutory notice to everyone. This was out in the open. And I just want to clear this up. as well, when they ostensibly, purportedly tried to pay their pro rata share, they made out a check to me. It wasn't that they made out a check to Mr. Parsons. They made out a check to Sandra Slayton, Esquire, whatever, Sandra L. Slayton, and they did it from a company, from some other LLC. We don't even know what it was. But of course they sent the check back. That would have given me, ethically, I would have even had a problem taking that check because, I mean, I'm not representing them. And then the burden would have been on me to go down to the treasurer's office, or I don't know what I would have been expected to do. But it wasn't in my client's best interest for that to happen. So here I would have been holding a check to me personally. I mean, that is not an accepted form of doing business. And the second thing, as Judge Brown pointed out, it did not include attorney's fees either. So I believe that the record is so clear that the facts of Kamen are distinguishable. Mr. Parsons there was no fraud, there was no deceit, there was nothing underhanded that happened in this case. And interestingly enough, the motion for summary judgment was signed, when was it signed, Kristen? The motion for summary judgment? It was signed, I think, back in April 2016. And the judgment, and they knew at that time that they had lost the motion for summary judgment, right? And they could have that day, or the next week, or the week after that, actually 4 months, they could have gone down to the treasurer's office until judgment was actually entered at the treasurer's office and recorded. They could have redeemed at that time. We couldn't have stopped them. And they didn't. In fact, we even argued in our motion for summary judgment papers to Judge Gama, geez, if they want this, they have to go redeem. And this is how they have to redeem. And so we were giving them the statutory remedy to do this. Hello, go redeem if you want to redeem. They didn't do it. And so nobody was trying to trick them. And the final judgment wasn't even entered until the following, I would say January of 2017. And the reason it took so long, Your Honors, is because there were so many people that had individual little third and fourth and fifth liens on this case. Maybe I misspoke when I said fifth liens. There may not have been a fifth lien, but a lot of little interests that we needed to, and opposing counsel was very cooperative in that, and I thanked her for that. Very professional. We literally needed to make sure that there weren't going to be any outstanding interest that came in after the fact. So we had to do one default after another until we got everything cleared, and then the court signed its final amended judgment. And until January of 2017 even, they could have gone down and redeemed under what is their right to do. So I don't believe there is an issue in this case, and there was no fiduciary duty between Mr. Parsons and the appellants. It would be like, I was thinking about this last night while I was preparing, it would be like if Jane Doe came up to me and said, I want to borrow $500 from you. And I said, well, okay, I have $50,000 to give you, $50 to give you, but my partner, Kristen Roebuck, is going to have to give you the other $450. She'll have to lend you the other $450. And the person said, okay. And so Kristen would give the person $450, and I would give the third party $50. Would Kristen and I owe each other a fiduciary duty? Of course not. Like, we were just two lenders. So I don't think that any of the cases.
Does the 1% interest retained in Buckeye change that at all?
No, in fact, it strengthens it because that operating agreement is so clear. Well, first of all, you have to understand that the appellants were not a member of Buckeye. They didn't even belong to Buckeye. They were just Mr. NACE's children, and that was it. So the point is that the 1% interest really, I mean, he was a minority passive investor, lender of Buckeye, and his rights were very limited under that. He was not allowed to take action.
Before we run out of time, did we find the promissory note in the record?
I believe it's 87. I was still trying to confirm.
87.
Okay.
87. Okay. Thank you.
And I have nothing further, if the court has nothing further of me.
Thank you, counsel.
Thank you so much.
I'd like to address the argument about redemption. While it's true a beneficiary has the right to redeem the property, the problem we have here is my clients were a 25% owner, and they had enough funds to redeem 25%, but not 100%. Under the deed of trust, in its paragraph 1C, they could not require that Parsons advance his proportionate share because under that provision, Parsons had the control. He had the right to make decisions to advance money to protect the trust property, and if the other beneficiaries wanted to, they had to get Parsons' consent. So it wasn't as simple as easy as allowing the beneficiaries to go redeem their 25% share. They would have had to redeem the entire amount. There was a question about Parsons being a 1% member in the LLC. Granted, he was only a 1% member, but remember, in that LLC operating agreement, he also had veto rights, just like he had under the deed of trust. And according to Don NACE's declaration, Mr. Parsons would not allow him to go out and borrow money to pay for the taxes because the lender would have required a subordination, and Parsons was not willing to do that. I'd like to go back to the Cammon case because I know there was some discussion about whether or not there was anything that was fraudulent or secretive. The discussion in Cammon about the fraudulent or secretive was only regarding piercing the corporate veil or treating the alter ego. The only issue was whether or not the corporation should be considered to be part of the owner because of the way that was done. We could disregard that for purposes of this case. We don't have that situation. Justin, the owner, is just like Parsons in the trust as the beneficiary. And I know that the appellees would like to treat owners different from beneficiaries, but if you remember in Cammon, the court looked at the general rule and they said it applies to anybody that might redeem from the tax sale. Might redeem from the tax sale is the owner and the beneficiaries. And the court looked to other cases, which obviously from Illinois, but other cases which said that in equity, a beneficiary or a mortgagee should not be allowed to do exactly what Parsons did here.
I keep coming back to just wondering what happened at the beginning of this. And I remember the real estate market. I was doing real estate law, and people would enter into contracts, and 30 days later, the property was increasing in 5. And then by 7, 30 days later, it had decreased in value. When you enter into an agreement like this and you know that you were going to have 25% only, and the real estate market is volatile, if you can't afford to redeem in the event of a tax lien or pay the taxes, don't you know that going into the transaction?
Your Honor, again, it's not part of the record, but I think both counsel and I agree on what occurred. The market was horrible. And if you recall, they purchased this to save the property out of a bankruptcy. So it was basically a last-ditch effort to get it out of another bankruptcy in order to try to save it. Everyone knew that the taxes were delinquent at that point. Everyone was able to come up with enough money just to buy it out of the bankruptcy, and there was not sufficient funds for the taxes. And I think you or maybe Ms. Slayton mentioned about people were all optimistic. Everyone hoped things were going to be able to turn around and they were going to be able to afford to bring the taxes current and hopefully sell the property and make a profit and divide the money amongst all the lenders or investors, but that obviously did not occur. So I think, yes, they probably had a lot of high hopes back then.
Okay. Thank you.
Mm-hmm. Any questions?
Any questions?
Well, that was easy. Okay. Thank you. Have a nice day.
Thank you very
All right,
much.
thank
Nice
you.
arguments, ladies.
Thank you, counsel, for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We're adjourned. Thank you.